Good evening, everyone. This is the regular meeting of the municipal land use board for River Edge for Wednesday, February 11, 2026. Time now 7:32 p.m. This meeting of the municipal land use board of the borough of River Edge is being held both in person and remotely via Zoom in compliance with the provisions of the Open Public Meetings Act and associated regulations. Notice of this hybrid meeting was published in the Bergen Record, posted at Borough Hall, and posted on the borough's website. The notice included the dial-in and login information necessary for public participation and access to this meeting remotely. A copy of the agenda for this meeting was made available on the borough's website near the posting of the meeting notice and included the dial-in and login information. During the public comment period of this meeting, if you would like to make a public comment, you may step up to the microphone and wait to be recognized by the chairperson. Press the raise hand button on Zoom or dial *9 on your telephone keypad to raise your hand. You may mute and unmute yourself by pressing the microphone icon on Zoom or dialing *6 on your telephone keypad. You must state your name and address clearly prior to making a public comment. Please stand and salute the flag.
Ready? Salute. I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let's call for
Mr. Mayor,
Here, okay.
Mr. Castle,
here.
Mr. Craig,
Here.
Ms. Boland. Here. Mr. Givens,
Here.
Mr. Kanika,
Here.
Mr. Salva,
Here.
Mr. Codier,
Here.
Councilman Black.
Here.
And Ms. Levine. Here. Also present, we have our board planner, Mr. Barron, and our new board secretary, Jessica Hall.
Since we have that on the agenda, seems welcome.
Thank
Glad to
you.
have you here. Forward to working with you. Really find we're easy bunch to work with.
Thank you. You,
Best of luck going forward. At this time, I'd like to ask for a moment of silence in memory of former board member, Dick Vernon. As you know, Dick unfortunately passed away, last week. Dick was a fixture of this board for a very long time, 1988 to 2025. Dick sat in this chair from 1993 to 95 and was my right hand for 2017 to 2025, some of my time during that period. But Dick was a tremendous asset to this board, as you well know. Have a chance to work directly with him. The level of detail which he approached each and every application was meticulous, measured, looked at all angles, kept the board's interest, the town's interest, and the applicant's interest in a very measured and balanced fashion in looking at all of the facts and information in any given application. And I think fair is probably an understatement to attach to Dick. And certainly he was fair with the applicants, professionals, and calling them on the carpet for, consider that their plans were detailed, because that's the way Dick was a detailed guy, and he wanted to make sure that the professionals were held to as high a standard as he held himself. So at this point, I'll open the floor to like to say a few words about that.
Benson. Dick Vernon was just really a fixture in River Edge, and great person to call for historical knowledge and for an honest and thorough response on anything. I was glad to work with him all these years. I've been elected official for starting the 15th year, and he's just a fixture in River Edge and a fixture of devotion for the town, commitment to the town, and he will be missed. We were honored as a council and I as mayor to recognize him at a meeting not so long ago where we gave him a plaque about a year ago. And He shall be missed.
I think Dick was one of the reasons I'm sitting here now. You know, he was definitely a mentor to all of us. He helped me learn more about what this job is and actually encouraged me to actually go visit sites on occasion when it was warranted. You know, and I know he taught a lot of us so many things about doing the right thing up here. You know, like you said, for the applicant, for the town, for everyone. And he's definitely sort of.
I think there's just one other thing I'd like to add. Aside from all his technical acumen and all the work he did and how dedicated he was feisty. And that's the memory I have.
I have a feeling that a fair number of applicants in my. Let's stay on. Thank you all. At this time, we're going to move forward in our agenda. We're going to modify the order slightly. We're going to move to the swearing in of new appointments. With a class meeting member, Councilman Dave Glass, who will be sworn in for a new one-year term. Then you do the honors, please.
Sure, Councilman, if you'd please stand. You raise your right hand and repeat after me. I state your name.
David Glass,
Do solemnly swear
do solemnly swear
that I will faithfully,
that I will faithfully,
impartially,
impartially,
and justly
and justly
perform all the duties
perform all the duties
of the office of Class 3 member
Class 3 member
of the Borough of River Edge
of the Borough of River Edge
Municipal Land Use Board
Municipal Land Use Board
to the best of my ability,
to the best of my ability,
and that I will support the Constitution
and that I will support the Constitution
of the United States
of the United States
and the Constitution
and the Constitution
of the State of New Jersey,
of the State of New Jersey,
and that I will bear true faith
and that I will bear true faith
and allegiance
and allegiance
to the same
to the same
and to the governments established
and to the government established
in the United States
in the United States
and in this state
and in this state,
under the authority of the people.
under the authority of the people.
Thank you.
Thank you.
Welcome back, Councilman.
Thank you, Chairman. Happy to be here. Honored to be here.
Excellent. At this time,
I'm just going to make an announcement. On our agenda, we have, old business matter, IAAT Services LLC, an application, related to 41 Grand Avenue Block 1405 Lot 4 for preliminary and final site plan approval with use, height, and bulk variance relief to construct and operate a double-face static billboard sign on a single monopole. The applicant and the objectors' councils have requested that the hearing on this application be carried to the February 25th, 2026 meeting, without further notice. So if you are here for that application, it will be heard again on February 25th, 2026.
Okay, at this point, we're gonna move back up in our agenda. We're going under discussion items, item 2, for our affordable housing compliance and housing element and fair share plan updates from our board planner, Tom Barnes.
Good evening, just give me a moment while I get set up here. So for the purposes of facilitating this update, I did a very brief,
I need to activate the mic.
on my end, or,
So just do it on the table.
so I am connecting via Zoom, so I was trying to avoid the double mic issue.
I promoted you to panelist, and then just mute your computer and turn down the audio.
Thanks.
I think that should work.
Just bear with me like it's.
You can turn your video off too, and then unless you want.
we have that up, so feel free to look at either the screen behind you or the screen this way. And again, I thought just having some visuals would help facilitate this conversation. So Tom Behrens, board planner with Burgess Associates, we've been helping the borough address its affordable housing obligation since the third round. We are now in the midst of the fourth round of the state's affordable housing obligations, which officially began in July of 2025 and will last for the period until June 30th, 2035. So essentially for a 10-year period. We were last before the board on June 25th of 2025, at which this board adopted the borough's fourth round housing element and fair share plan to address its obligations at the time. I'll explain a little bit about the process, where we are, some changes and updates and outstanding tests for the board moving forward. I will say that since we last met, we've been working with the council to resolve some issues, which I'll explain. And so, you know, a lot of this, as it involved litigation, had to be, wasn't able to be publicized essentially until now. But again, I'll go through the process and explain sort of where we are and what we need to do and why. Essentially, we're still dealing with this at this point. So process-wise, you may recall, and I'm not going to dive too deep into history, but basically the state came up with a brand new process for how it would assign municipal affordable housing obligations. That was as recent as March 2024. Again, there had been a prior process which worked fairly well for rounds 1 and 2. Round 3, the state tried to come up with a new process, basically ended up in litigation. It was a nightmare. The borough got through that. You know, we came up with a couple planning options that worked out pretty well. And here we are in the fourth round. And every municipality that's participating in this fourth round was all trying to make sense of this new legislation by virtue of the Fair Housing Act that was amended by the state, signed by Governor Murphy in March 2024, which was frankly filled with ambiguity in some cases and left with towns trying to understand what the requirement was and how the process would work. And frankly, none of the participants quite knew how things would play out. So it was you know, totally an evolution, and things have evolved since we last met as a group in June of 2025. So the state, after the legislation was adopted, assigned municipalities their individual affordable housing obligation on October 2024. If you may recall, the state comes up with a total statewide obligation of what it thinks the state owes from an affordable housing standpoint for the 10-year period. Came up with a number of about 85,000 affordable units statewide. That trickles down into regions. River Edge is in Region 1, and that regional number then trickles down to municipal obligation. So our assigned municipal obligation from the DCA was 159 units, again, for the fourth round period. By January 31, the borough complied by accepting the obligation of the number that was assigned by DCA, again, that 159 number. There was a period where if you didn't accept that number, that could be challenged. That wasn't an issue for us. So we went ahead and adopted a housing element fair share plan on June 25th, again, of 2025 to address what we understood our number to be at that time. Interested parties had until August 31st to challenge any municipal plan, and throughout the state there were challenges all over. There's an affordable housing advocate group, essentially a lobbyist by the name of Fair Share Housing Center, that challenged over 420 something municipal plans and challenged River Edge. So basically any town that adopted a plan, the plan was challenged with very few exceptions, and I'll explain what that means for us. So where we are in the process is that we made it through the challenge period. We worked through our issues with Fair Share Housing Center, who was the sole challenger to our plan and had some technical issues. And we worked through what was called the Affordable Housing Dispute Resolution Program, which entailed a former Mount Laurel judge and a special adjudicator, formerly special master, who was essentially a licensed planner. So the judge and adjudicator were the mediators in this process, where the borough was one party and Fair Share Housing Center was another party. We lucked out in that we didn't have any developer objectors or challengers where other municipalities had 15, or it got pretty crazy for some of the other towns that we worked with. So we were lucky in that we only had this one challenger. So those issues were resolved, culminated in a settlement, a mediation agreement with Fair Share Housing Center between the borough, which was finally executed in January 7th, 2026, which I'll explain. So at this point, we're in the approaching the March 15th, 2026 deadline, whereby municipalities must adopt any ordinances that implement the plan. So we haven't adopted any ordinances to date, knowing that there would be this challenge period, likely a mediation period. So I'll get into what we own by when, just letting you know where we are. Then once we get through that deadline, assuming we submit everything, this board and the council adopt the various documents, we'll be eligible for compliance certification from the Mount Laurel judge. So every municipality is assigned a Mount Laurel judge to look at your case, to see what's done, to see that you comply with the law. And the significance of that, the question is, well, why are we participating in this process, is that at the end of that, a compliance certification gets you immunity from what are called builders remedy lawsuits. So if you don't have that certification, basically any developer can come in at will, pick a site and say, town, you haven't complied with your state, your constitutional obligation. It's a constitutional obligation. So we're here to do that for you. And by the way, we're going to exceed your town zoning because you haven't done anything. So oftentimes a developer will pick a site, let's say your zoning allows 2 stories, they'll end up at 4 stories, for example, and a lot more units than you would normally allow or contemplate. So the immunity allows municipalities to retain control over their zoning ordinance. So while we've had to bend a little bit in certain areas, again, I'll explain that. In general, the immunity preserves our zoning for the most part, again, for the next 10 years. So we don't have to be worried about, sites coming online, which there are sites that arise periodically. So I think we are a little bit more vulnerable in that regard. So, and so it was our recommendation that the borough stay the course and secure immunity. So without further ado, I'll just give an overview of the fair share obligation, just as a reminder. So, again, the DCA gave a 4th round present need, which is a rehabilitation obligation of 32 units. That pertains to rehabbing existing units. That's the number the state gave. They gave us a prospective need obligation of 159 affordable units. So that's essentially the number that they're saying River Edge owes. So you have to build 159 new affordable units in that 10-year period, which translates to the number, basically 5 times that number when you do it in an inclusionary setting, whereby you have essentially 4 market rate units to 1 affordable unit. That's the standard ratio. So that's the amount of housing activity the state indicated that we have to develop. We're not doing that, just to be clear, and I'll explain how that plan is able to reduce that impact. Again, the overall arcing goals of this participation was 1, compliance to promote the immunity, and 2, to do it in a way that minimizes impacts to the borough in every single case. So first off, we were able to adjust the rehabilitation obligation from 32 units to, sorry, Ms. Green's covered it, to 7 units. And that was done by structural condition survey, where in coordination with the construction official, did a drive around town to see how many units actually qualified. And so we established a rehabilitation obligation of 7 units. In the past, we've satisfied this obligation with working with the home improvement program in Bergen County. We expect to do the same, so we're hoping we can work with them to take care of that obligation for us. Now, while we had the larger number of 159 units, we were able to adjust that number through what's called the vacant land analysis. We did that successfully in the 3rd round, where basically there's certain criteria. You look at minimum land area threshold and sites that are impacted by environmental constraints, and sites that are vacant or undeveloped, essentially. And because the borough has no land that qualifies for that number, that what's called the realistic development potential, that considers that criteria, is 0 units. And again, that was the same number for the 3rd round. River Edge didn't make any new land. There's no new vacant sites. So effectively, that adjusted our prospective need obligation from 159 to 0. Story doesn't end there, so it gets a little more complicated. So a new feature of this 4th round legislation is this sort of ambiguous redevelopment requirement, where it said that towns that sought an adjustment through a vacant land analysis had to consider sites likely to redevelop. This is a mouthful, to address a portion of its unmet need. And that number would be calculated based on the prospective need that was adjusted. And so there were 4 different interpretations statewide as to what that actually meant. We took one position that basically said, well, if you think about it, then, from a common sense perspective, from a literal perspective, it would mean 25% of your realistic development potential. Another interpretation, which towns tended to settle on, was this 25% of the unmet need. I know I'm using a lot of jargon, so I'll try to explain it, and I understand if you have questions. The unmet need is the difference between the state number and your adjusted realistic development potential. So the difference between 159 and 0 in our case is 159. So the interpretation of 25% of that 25% of 159 rounds to 40. So that became the magic number that we had to try to satisfy in order to have a successful mediation through the program with Fair Share Housing Center. And ultimately, we were able to do that. And I'll explain how we got there in just a moment. So just a very brief overview of how we satisfied the third round, just so you recall, included units from the senior residence at St. Peter's, 18 units of the 23 units there. The reason we couldn't use all of them is because there's a senior credit cap of 25 units, 25%. We also have 3 existing group homes, one at 11 June Court, one at 200 Zabriskie Place, and one at 328 Valley Road. And in the third round, the borough also adopted 2 new redevelopment plans, one for the Newbridge Landing Station redevelopment area, which is essentially both sides of the Newbridge Landing train station that partially owned by NJ Transit and partially owned by the borough. And then we had Kindercamack Road redevelopment area, which is essentially where Let It Grow headquarters is, as well as the adjacent laundromat at the corner of Ackerson and Kindercamack Road. So that's how we addressed our third round plan in full, secure immunity up until the fourth round. This is just an aerial image of the Newbridge Landing redevelopment area, just for orientation purposes. So again, it's both sides of the tracks. I'm going to flip through these quickly because you see them. And this is the Kindercamack Road redevelopment area, again, where Let It Grow has its operations. There's a smaller vacant parcel that kind of triangle, but the one that abuts Route 4 and Lot 5 is the one that's developed with the laundromat. So without further ado, getting to the plan and the basis of our negotiations with Fair Share Housing Center in consultation with the council, this is the compliance plan that got us to the 40 unit number that one, the program and system we had to get to, as well as the special adjudicator. So I will say that we did our best to try to again whittle down the impact and to try to comply with the fewest amount of units throughout the town. And this is what we came up with. It was also in consideration of sites that from all perspectives would be the best redevelopment sites in the town. If you had to pick a site, these sites make the most sense from an availability standpoint as well as an impact standpoint. So the first line item on the chart is just the surplus credits from the St. Peter's senior residence. Again, we have the 5 left over from the 23 units that are there. We have the Newbridge Crossing development. This is, just to be clear, this is an existing development. That's the new apartment building on Kindercamack Road, just south of Howland. That's a 69 unit development with 7 senior units. That's developed, that's occupied, that's not new. A new zoning feature of this compliance plan is what's known as the Johnson Avenue Overlay Zone. And I'll show you an aerial image just to orient you. It's essentially on the south side of Route 4, pretty much disconnected from the rest of the borough, but within walking distance to the train station. It's across from, is it Prime 59? Is the steakhouse there? And so it's developed with a hodgepodge of essentially industrial uses of what had been a retail store. And my math indicates that it's about 1.57 acres in the area. So the idea, what the agreement rather was that there would be an overlay zone, which means that you keep the existing zoning in place. And that site in particular is in the borough's C2 zone, which allows for a variety of commercial uses. An overlay zone, it becomes an optional zoning framework where the property owner has the option to develop that in an effort to promote affordable housing. And again, this is a mechanism that was used as a compromise. The residential density there, if this overlay zone is exercised, would be 40 units per acre and would require at least 20% of those units to have affordable housing. If that were built out, that would result in 13 affordable housing units. And that's in an ordinance that the Borough Council will have to adopt on March 5th. The fourth line item is what we're calling North Kindercamack Overlay Zone. And again, I'll give an overview of these in just a moment. That encompasses the Riverdale Filling Station, which is Kindercamack Road at the extreme north end of town, as well as the adjacent Verizon site. And that's another overlay zone where, again, the underlying commercial zoning is not being removed. We have to create, what the law requires is that you create the opportunity. The borough has to create the opportunity. It doesn't have to pick a developer, doesn't have to come up with a plan. It just has to put the zoning in place to say that when and if it gets developed, it could produce some amount of affordable housing. So given the sensitivity of that area, that it abuts single-family homes to the west on Summit Avenue, it has a much lower density there of 15 units per acre and 20% affordable housing set aside. If built out, if that whole site were built out, it's a little over 2 acres, that would result in 7 affordable units. The next mechanism is an existing plan mechanism from the third round. Again, this is the Newbridge Landing Station redevelopment plan. The adjustment here is simply adjusting the density upwards from 25 units per acre. That's in the existing plan that was adopted, so it's in place today, increasing that to 36 units per acre, and that would result in a total of 29 affordable units. The next is what's called the Affordable Housing 1 Overlay Zone, which is an existing overlay zone that covers on Newbridge Road, the BP gas station, the virtual golf simulator facility, and the adjacent plant store. So again, those businesses can remain. We're not saying they have to leave, but the zoning is now in place that when and if those sites ever develop, they could be developed with housing. That the only change there was increasing the density from 20 units per acre to 25 units per acre. And then finally, we have another existing zoning that is the multifamily and senior conditional use zone. That's the undeveloped part on Kindercomack Road where the 3-story apartment building is on Kindercomack Road. All the area on we'll call it the east side of Kindercomack Road, that's north of that development up to Howland Avenue, is in this zone that exists today. And that was created, I think, sometime around 2009, if I'm not mistaken. The only adjustment there is increasing the affordable requirement from 15% to 20%. And the only other thing we have to do is, in the third round, we had to create or adopt what's called a mandatory affordable set-aside ordinance, which means that any development that we haven't specifically identified, if there's housing development of 5 units or more that occurs anywhere else, then it would capture some amount of affordable housing. The ordinance currently reads that a rental project would have to have 15% affordable housing requirement. That's being increased to 20%. And this is sort of a standard municipal requirement across the board, and almost every town we're aware of is adjusting their ordinance similarly. So it's sort of a standard ordinance that towns are relying on. So I'm going to go site by site. We can stop and pause where we need to. This is an existing senior housing at St. Peter's. It's, you know, if you're looking at the church, it's attached to essentially the school building, 23 units. I believe it functions as a senior. I think it qualifies as assisted living, but nevertheless, it counts as senior affordable housing. The next, as I've alluded to a few times, is this Newbridge Crossing development. Again, this is the one on Kindercomack Road, south of Howland. On the east side of Kindercomack Road, it exists. We're taking credit for it, as it includes some number of affordable units. This is the new overlay zone on Johnson Avenue that I was referencing. So you have Route 4 to the north, you have Johnson Avenue to the left, and I forget the name of the street, frankly, and the site itself is bisected from Hackensack. So the border of Hackensack is immediately south of the site. I mentioned again, it's about 1.57 acres. It would include all 5 of those parcels. And again, the idea is that if that site were to be developed with residential development, it would have that zoning programming of 40 units per acre that a developer in theory could take, could develop the site. I'm going to pause there because this is something the board has not looked for. Does anyone have any questions?
What did you say, 40 per acre for that?
43.
So just on a site like this, the developer can't come in and not abide by our zoning because we're doing this, so they still have to abide by whatever number you said before.
Right, the purpose is to set a ceiling and say, this is what you can do, and again, this is an area that would seem to be right for development. I know it's been discussed for a long time, it's in close proximity to the train station, and it was identified through the participants of this program as, again, if you had to pick a spot in River Edge to, you know, provide zoning for affordable housing, that this stood out as being a reasonable location among others.
Just as a benchmark, if I recall correctly, Newbridge Crossings is about 37 units per acre, is that right?
For reference, right? So
Yes,
so
that's a good bench.
So this site right here is approximately 37.5.
So that gives you like a benchmark.
So when you think about scale and
Right.
parking requirements, et cetera, it would be
So
similar.
they have to abide by all of our zoning. They can't just come in and say we're doing what we want because we're doing what you've done.
Because we have that immunity, and that's the importance of the immunity, is that they have, any prospective developer has to abide by our laws. And that is the purpose of all this. And again, when you look around the south end of town and even on Kinderconnect Road, you start to say, these things could be redeveloped because there is a market, frankly, for housing in River, right? So the goal was to try to control zoning and minimize the impact to, the existing community. So this was a site that was selected, in that process. I'll move along. I'll open it up for questions at the end. The next site is, what was being referenced as the North Kinderconnect overlay zone. That's the area highlighted in yellow. To the extreme north of that area is the border with Lauderdale. The northernmost parcel is the Riverdale filling station, which actually occupies, two adjacent lots, lot 2.01. And I believe that site in total is about 1 acre, if I'm not mistaken. And then just south of that is a surface parking lot building, that's historically been occupied by Verizon. Again, this was a site that was identified by, through this process with the program participants. Where this site varies from the other one, obviously there is surrounding development, the lots are a bit smaller, it's a little more, congested is not the right word, but developed in this area. And so the thought was that, a lower scale density would be more appropriate to minimize impacts, or really prevent any impacts from surrounding residential development in particular. And the contemplated development format would be in either multifamily or, mixed use format. So that's essentially what the zoning option would allow. So again, there's no developer has been selected. This is just to create the opportunity, an extra zoning alternative, that could produce affordable housing.
And just to be clear, so these lots are a little bigger than the other one. So if someone owns, I guess you said that the filling station is on the top two lots. So if someone wanted to take those two lots and develop those, they would be or they would be able to take advantage, I guess, of the.
They'd be able to, develop in accordance with that zone.
So you don't need to use all, you can use some of it if they.
Oh, right. You can use part of the zoning, you could, for instance, just develop the Riverdale filling station, so that would be one option.
Or you could develop it as what the existing zoning is, correct?
Right, the underlying commercial zoning would remain the.
Right, so if someone's going to develop that, they don't have to use this.
That's correct.
So they could
Second
build
option.
another gas station there,
Yeah.
or whatever.
Yes, that option, right, so nothing is being stripped away as far as development potential, what's currently allowed, so this is just an added option that the state requires, essentially. You have to create zoning mechanisms that allow for affordable housing to be developed, in reasonable ways, or hopefully reasonable ways.
And one question.
Yes,
There's, I want to make sure I understand. There's a target, that's in the plan of how many units would be in this zone. I'm gonna guess that those target numbers exceed what we would typically do within our zone.
well, for this site in particular, zoning today actually doesn't allow residential development. So we took a look at what are the different iterations that could somehow allow, residential here. I think if you look at the filling station, that's another site, it's a gateway to town. I think everyone that drives by goes, that could be better. And so, there's a market for only certain types of uses in River Edge based on, what can be financed, what there's demand for, et cetera. Obviously, there's always going to be a demand for housing in River Edge. So it seems sensible that this site was identified as one that could be redeveloped and would check a number of boxes from a planning standpoint, being that it would develop a site that's underutilized, be a drastic aesthetic improvement, for gateway to the community, and then also satisfy a portion of the borough's affordable housing obligation to alleviate pressure elsewhere. Essentially.
But if the target development number, exceeds what our zoning would require, then who wins?
Well,
It's not really a target, it's just what we would allow.
it's a maximum.
It's
So we're
what
saying
the zoning would be. There'd be new zoning allowable.
Right,
development.
So we,
It's not a target, it's what would be allowed, cap.
it's a cap, that's
Right.
another way.
Right, but we, I thought the goal here was so that our zoning would be utilized. So it's not actually our zoning, it's what we agreed to here.
It's, right, the zoning currently doesn't exist.
Right.
And through this process, through, working with the different participants, that a new zoning option be created.
And so the goal is not to, the goal, as you stated, is not really what we were doing. The goal is to prevent us from losing immunity. And for the public's sake, what that would mean is, so say there was, we didn't go for, the settlement state and affordable,
Fair share housing.
fair share housing. Then we would not be living up to what the state expected of us. Developer could come in and say, buy a lot, and say that lot just happens to be in a residential area, and say, well, I'm going to build a 7-story apartment building right next to a single family home. We have little option other than to enter into a court case with them, which we would lose to some extent. We could not wait. This is not development that is going to happen. This is development that could happen, but we control the zone. And so in some places, when we say there's an overlay zoning, what we're doing is saying there's now zoning option A, zoning option B for just that area. So, so it could conceivably go as much as, 40 times 5 is 200, right? We have to do 40.
Right, if we look at that target affordable housing, 40 times 5, right? In theory, if all of that would develop.
In that
zone?
No, dispersed throughout these various sites that in the chart that I showed, if you added that all up.
What's the maximum in that zone?
15 units per acre on 2 acres, it's about 30 total units, give or take,
30, so affordable would be
20% of that.
20% of that. And oh, I'm sorry. And if whatever structure was being built on that unit, to get to that number, we needed to exceed our height ordinance, wouldn't it?
Well, I think we're going to do it in a way that does not impact, particularly the residents on Summit. We know that's a sensitive issue with this building to the east and so forth. So I think we're probably going to keep it at the current height maximum. I think that's the goal. We said-
But if a developer wants to come in and say, I want to put all these units in, and it's gonna like really come in and satisfy your thing, the only thing stopping me is your height, requirement, what happens then?
Well, whatever ordinance we adopt, it's gonna have to make sense from a dimensional standpoint. And so that's something we're looking at, even though this has to be resolved in short order. So from that perspective, the zoning has to be realistic here for it. And we believe that it will be within that height limitation.
So the town is going to be introducing an ordinance to create this overlay zone. That ordinance is going to be referred to the planning board for master plan consistency review. And then it'll go back to the council to be adopted. If it's adopted at whatever the height is set, or whatever the bulk requirements are set in that overlay, and somebody comes in and they want to go crazy, they're still gonna have to come to this board and get reviewed again and say, well, we gave you all these extras in this overlay zone, and now you're still trying to go beyond them. Why, they still have to prove their variance and all their.
But if our ordinance doesn't allow them to meet what the stated goal is, then are we just putting that in the way? Is that an obstacle?
Our ordinance has to be practical.
Development. Right.
Yeah, so we can't create an ordinance that won't allow them to achieve it. However, for instance, in this particular site, we have the Verizon building. That is an active building. I can't imagine it going away for the next 50 to 100 years. So even though it's one of the areas, it probably will not be developed in our lifetime or our children's life. But we still were required by the state of New Jersey to do this. Now, you might also notice that, Tom mentioned that all this has to be done by March 15th. That is not our fault. That is not the fault of the 7 municipalities in Bergen County or the 560, 565 municipalities of the state of New Jersey. That is a requirement that the state legislature gave us, and it's a very tight, timeline.
So whatever ordinance we're working on is going to make sure to like talk about this is for this particular, and it doesn't affect any other ordinance in River.
It would be, it's site specific, right? So it's-
Also,
in this
just
case-
keep in mind, we only offered 15 units per acre here, so they can't go above that.
Well, that's the affordable house, right?
No, no, that's the density.
Okay.
That's the total density,
Total.
right? 15 is good?
1/20th of it is
So
affordable.
how many acres is that?
No, 20%.
All 4 lots is 2.13.
I think it's because of the question I was trying to ask, which is, you use the phrase recontrolled zone. And that's where it's real funny because like recontrolled zoning unless we're not meeting somebody else.
What are the parameters that they give us?
Right.
That's what it
Well,
is.
Yeah,
But you also have to consider there's areas in town where you are allowed to have commercial property and not, so we already have areas where the zoning is different. So it's just having another area where it's a little bit different to allow something like this.
But I understand the confusion, that it's that, well, you're saying we're controlling it, but we're changing it. So how do you square that? So and the reason is that the whole state program was designed to circumvent zoning to essentially fast track housing, you know, as in frankly disorganized way.
So essentially, we're being coerced.
You have to copy.
proper word.
But if we work with them, we get to maintain some control.
So we're giving them enough room.
But your example on the hypothetical, the 7-story building, somebody,
If we lost immunity, that could be very easily done. Where a developer comes in and says, River Edge has these great schools, has this great reputation, and I can talk people into selling their houses, and so I cobbled together 6 lots, and now I'm gonna put an apartment building, but I wanna put 50 people per acre, so I'm going to put it 7 stories. And you only have to go to Yonkers and other places where you can see things like that happen.
but we would need the immunity to prevent that.
Once we have immunity now, as long as we maintain immunity, the developer can't come in and simply say, too bad, so sad, we're gonna do whatever we want. And as our our attorney, Ms. Brown said, we now get to negotiate with them. Say they come with a development that we think is pretty good, but they need the sewage, they need this, they need that, and they want us to pay for it. We can say, well, you know, we'll negotiate that with you, like we've always done, streetscape, things like that. So we maintain the ability to keep River Edge. If we do not do this within the timeline provided by the current legislation, then we lose that. That would be devastating.
And a site like this, you know, we say, all right, try to do 2 stories, so we don't block the view of people on Summit Avenue. Someone comes in, they're putting in 4 stories, and now that person on Summit is looking at an apartment building.
Yeah.
So stopping that by, you know, because that would be a decent option for someone, easier than buying, you know, 6 adjoining lots on Elm Avenue.
Well, and just the most extreme local example is Angler Cliffs. They basically dug their heels in and said, we're not gonna participate in all this. And they had a Prentice Hall, which was a publisher there. And there was a developer that wanted to develop the site because the borough wasn't willing to negotiate at all. Basically, the court at that time retained control of the process. They ended up with like hundreds more units than the developer was proposed, so more than the developer had proposed. And beyond that, the court adjudicator, the planner, working for the state, became the planning reviewer. So the planning board lost all control of the whole process.
So they take over all zoning in town.
So that's an extreme case, but you don't want to end up there.
For historical reference, when this thing first was legislated, I'm assuming it was fought on the grounds of this is government taking it out, recognize.
Yeah, it's a long and tortured history that starts in 1970. I'll give you 2-minute version. I'll talk to you about it after.
Actually, it's worth it for anybody who might see this video. Would you just give a 2-minute version of Mount Laurel and
I think in the June
It's in the
updated
plan.
their housing element fair share plan, it did provide a Riverite specific overview and a little bit of the Mount Laurel doctrine history. I mean, general summary, I don't know if you
yes,
have
but
a 2 minutes.
I don't know that everybody will read that, and people will look at the Facebook, the Zoom
Yeah.
version on YouTube. So if you just,
Where did this come from, right? I'll give you the bullet points for it.
yeah, just go though.
I think it was 1975 was when the first Mount Laurel decision, was rendered by the state Supreme Court, known as Mount Laurel One. And what, happened there was essentially there was a group of, people in Mount Laurel who wanted to develop their land in a way that wasn't allowed by local zoning. They happened to be African American, and there was some, racist, things happening. Basically, they said, if you can't afford to live here, you have to find somewhere else to live. There's some other nasty things said. And so the issue worked its way all the way up to the Supreme Court, with the help of the NAACP with Fair Share Housing Center. I think at the time, the beginnings of what was Fair Share Housing Center. And that issue was litigated, and they ended up winning. And basically, what the Supreme Court had decided was not just Mount Laurel, but every municipality in the state of New Jersey had to provide for its fair share of affordable housing. Problem was, they didn't indicate what fair share meant. So years go by, no town does anything because they don't know what this requirement is, but they determined it was a constitutional obligation. So you can't walk away from a constitutional obligation. So that was a very important piece of that determination. Years go by, I think it was, if I have my dates right, 1983, I think was Mount Laurel 2, where basically the Supreme Court, I think it was there, but early 80s, mid 80s, the Supreme Court said, look, towns, nothing's
Don't
going.
emphasize again, the New Jersey State Supreme
The
Court.
New Jersey,
Because
yeah,
people
state
listen
Supreme
right
Court,
now.
right, basically noticed the inactivity at the municipal level and said, okay, we need to encourage the legislature to act. So basically, Mount Laurel 2 was a nudge to the state legislature to say, hey, guys, we have this constitutional obligation. You guys should really be administering this. So that prompted the state to adopt the 1985 Fair Housing Act, which created the whole framework for municipal obligations. It created the state agency, which was known as the Council on Affordable Housing, which was the agency in charge of administering all of these municipal requirements, the fair share housing obligation. So that entity, COA, then came up with the first round of regulations and state requirements. That was for the period 1987 to 1993. So that was round one. Every time there was a state obligation, and like in this period, every municipality got an obligation. Some towns participated, some didn't. Riverhead didn't happen to participate at that time. That round worked out pretty well. Towns got immunity, they got certified, once participated. Then there's a second round, that was from 1993 to 1999. Also worked out pretty well because it was administered clearly by the state. There's a clear set of rules. You had an agency that was relatively unbiased, that understood the municipal side, understood the affordable housing side, and so they were able to process things fairly well. Get to 1999, and COA decided to change the rules, of course. So it went from what was called a fair share methodology to a gross share methodology. So basically, the calculations to come up with a statewide number, then the municipal number, they came up with a whole new way of calculating that number, which ran afoul of I guess constitutionality, that's the word. And so that issue was litigated over a period of years, and they could, the Council on Affordable Housing couldn't come up with a set of rules that could be validated by the Supreme Court. And so finally, they had one final opportunity to adopt rules, and they had a deadlock vote of 3-3. So then, at that time, basically the court decided that they were defunct, that they weren't functioning as was given their mandate. And so the court took over the rest of the third round. So basically from 2015 to 2025 was the court process without clear rules, where the numbers were argued. It was frankly a mess, but River Edge was able to get out of that relatively unscathed. And then the state adopted this new fourth round legislation as recently as March 2024. That's what set the new framework in motion, where the state took over the process, created this new program, which included retired Mount Laurel judges. It had these special adjudicators who were planners, and then finally Mount Laurel judge who would determine compliance at the end of the process. So again, we're operating under that new fourth round process, which is for the period 25 to 2035. So that's what we're trying to address at present.
Succinct.
There's more to it in the plan if you're interested.
Yeah,
Um,
and on the website, if you go to the affordable housing page of the website, it has the most recent housing element fair share plan that has a very detailed.
A little more clear, yeah, take a look, yes. I'm just gonna go through the rest of the sites here. So again, Newbridge Landing Station, we just uptick the density, no other changes to the zoning there. But that's an ordinance in the form of a redevelopment plan that one line item has to be amended. This is that affordable housing one zone that, again, this currently exists. This is an existing zone where the density will be increased from 20 units per acre to 25 units per acre. Again, that's the BP at the south end, the golf training facility, and the what's now a plant store across from the Vaughan Student House. Those uses can remain, the existing zoning can remain. What we were required to do, and what's been in place for a number of years now, is create this option, right? So it could be developed in the future.
Is that something that has to be advertised or just on the books?
On the books, I mean, you create the zoning, and that's the obligation.
Well, it is being advertised
Well,
in
it's
that
noticed.
there's gonna be notice that's going out, there's gonna be public hearings on these, ordinances, and I'm probably jumping the gun for Tom, but we're gonna have a public hearing on an amendment to our affordable, our housing element fair share plan at the next meeting, which is also already done.
And I think this is the last slide.
Going back to that last one, doesn't that zone abut wetlands over there? Is that an issue at all?
The northern end does, so, I mean, whoever would develop this would have to comply with state regulations, but nevertheless, the zoning qualifies.
Gotcha.
And this, again, is an existing zone. It's tilted where the left is north, and the point of reference is that Newbridge Crossing development that exists. And so the remainder of that zone is what's already in this existing multifamily and senior conditional use zone, which just has to remain in place, essentially. That was created about 2009, if that ever serves me right. So just, Marina, so schedule wise moving forward, so at the board's next meeting, 2 weeks from now, February 25th, we're going to ask the board to adopt the amended housing plan. So we're basically taking the June plan, we're not reinventing the wheel. We're gonna update just the very specific sections about the changes that we just discussed. So I think there's one or two, well, there's about those two new sites we discussed, the changes to the density, and just a little bit, maybe 2 paragraphs on how the process has evolved. So in June, on February 26th, the mayor and council will introduce the various ordinances we've discussed. March 11th, the board will then have an opportunity to review for master plan consistency those ordinances. And then finally, on the next day, on March 12th, the mayor and council will have to adopt those ordinances. This all will occur within the March 15th statutory deadline.
So I want to underline that we are under the gun. We do not have any leeway. So, I know we all have busy lives and sometimes things come up, but we really need a quorum for both those meetings. So, please keep that in mind if at all possible.
So that's February 25th meeting, and then March 11th, the next Tuesday.
Right, and so the purpose of this work session was to discuss the changes ahead of time, so when you see that document, you know, what is this? So you're not seeing it for the first time, essentially. And I know the process is perhaps more abbreviated than we like, but that's a function of the state process, unfortunately. But I think this gets us to a good place for the borough, to the best interest of the borough. Again, we can preserve that immunity and retain the flow of government.
Didn't we have the same basic amount of time last time we did it? It's very compressed and long.
Well, right, so it had to be adopted by June 30th, except we didn't get our number until, it wasn't like certified until February, essentially. So there was only a few months to try to work that out. Right? And again, because it was a new legislation, everyone involved basically throughout the state was trying to make sense of what these requirements were. And some of that is still being litigated. For our purposes, we didn't think the risk was worth, it made more sense to just try to address what we could and move on from the process.
I assume I know the answer to this question, there's no end to this.
And to, not that,
I mean, it's just, you know, round 4 goes to round 5, to round 6, to round 7, and they're just gonna keep doing this forever. And
one could anticipate that there will be a 5th round. I hope the current legislation we have in place is modified, that it's, for a number of reasons, I don't
You
know.
just, you guys wonder the amount of money that's spent by this borough and towns across the state and the state itself, how many houses you could have built.
I don't disagree, and there are towns, in fact, that are actually exempt from this requirement, which you might find interesting, so.
Yeah, it just seems ridiculous that we're spending all this
I,
time, money, resources, and.
Which towns, what are the standards?
well, so your, urban aid communities, so Jersey City, Montclair, Bayonne, so, you know, some of these communities, not all, are going by leaps and bounds, and they're technically not required to have housing, so it's just, but their obligation gets redistributed to towns around such and so.
Certification runs until what year?
2035, so it's 10 years, so
So you should effectively be done with this until.
if we meet these March 15th deadlines,
Yeah.
the Mallory judge will review what we've done, see that we've, settled with Fair Share Housing Center, and we very likely will get a compliance certification, which secures immunity. So we have immunity today, we continue to do what we have to do, we'll keep that immunity for the next 9 years, whatever.
And then there is a, required midpoint review, I believe, where in 5 years, the town has put together a report saying, we adopted all these things in accordance with our plan, we're doing X, Y, Z to try and achieve it. Some things got developed, some things didn't.
It's a progress report heading through the process. That's, again, we'll have a plan for the board to review it. Again, it'll largely reflect the plan that you've already seen and adopted, but with those changes.
Any more questions?
All right, thank you for your time.
Thank you, Mr. Barris.
Yeah, thank you, very thorough,
Yeah.
thank you.
Wonderful.
I know you guys are all putting in a lot of time and effort into this, so thank you. It's not easy.
There are no members of the public.
If there are no members of public present, we'll proceed in. Questions, comments from the board? Look for. Look again. So moved.
Second.
Favor?
Aye.
Opposed, abstained?
Oh, drink everybody down.